Hello, and thank you for attending Committee of 100's event, Racial Disparities in Economic Espionage Act Prosecutions, a window into the new Red Scare. Today's event will reveal new research jointly led by Committee of 100 and Andrew Kim, which sheds light on significant racial disparities in the implementation of the Economic Espionage Act and under the China Initiative. Data from the research is drawn from nearly 300 defendants across nearly 200 separate cases. And now, to begin the program, I introduce Gary Locke, Chairman of Committee of 100, President of Bellevue College, and former U.S. Ambassador to China, for the welcome message and opening remarks. Gary, the floor is yours.
Very much, Charles, and welcome everyone to this incredible seminar led by the Committee of 100 as we look at the Economic Espionage Act and its impact on Asian Americans, specifically Chinese Americans. Committee of 100, commonly known as C100, has a dual mission to promote the fair opportunity of Chinese Americans in all aspects of American society, but also to promote mutual and constructive dialogue and understanding between the United States and China. Part of our mission, as I said, is to promote the fair opportunity for Chinese Americans in the United States. And clearly, with the growing security concerns with China, we're seeing an unprecedented amount of hatred and violence toward Asian Americans, fueled by such terms as the coronavirus, the China virus, the Wuhan virus, and the Kung flu virus. And while we're all concerned about our national security and we need to protect our trade secrets, our sensitive technologies, how America goes about it, how the Department of Justice and the FBI go about that needs to be kept foremost in our minds in terms of fairness, due process, and adherence to the rule of law. We've seen so many troubling cases, and much of it has been anecdotal about people being rousted from their homes in the middle of the night at the point of rifles and machine guns, and entire families being rousted out, and people being led out in front of their colleagues, arrested in handcuffs. But finally, we have some empirical research on the real impact and the disparities in the treatment of Asian Americans, Chinese Americans, as America goes about trying to protect its national security. We have a great panel of distinguished individuals, former members of the Justice Department, elected officials, members of Congress, esteemed professors from various law schools across the United States. And the results of Mr. Kim's research, who's a visiting scholar at a law school, South Texas College of Law in Houston, is absolutely eye-opening and quite shocking, quite frankly. And he'll present his findings in just a few minutes. But all of us who are law-abiding citizens who care about America, its strength, its vitality, have to be concerned about the way the Justice Department and the FBI and law enforcement have been pursuing these Economic Espionage Act cases. The disparate, unfair, unequal, discriminatory treatment of Chinese Americans, Asian Americans, in contrast to people with non-Asian names, is absolutely shocking and unacceptable. So I hope you enjoy our presentation with distinguished guests, as well as a robust discussion led by some very prominent individuals. And we hope that you'll take this information to heart. Committee of 100 is proud to have jointly conducted this research with Mr. Kim.
Thank you, Gary. Now I'd like to introduce Representative Judy Chu, U.S. Congresswoman for the 27th District of California, on the impacts of racism and bias.
Hello, I'm Congressmember Judy Chu, and as the chair of the Congressional Asian Pacific American Caucus, or what we call CAPAC, I'm so proud to be a part of today's important conversation. And I particularly want to thank the Committee of 100 for your leadership, not only in putting together this new report, but for all you do every day to promote the Chinese American and Asian American communities. That work has never been more important than over the past year and a half. Not only have Asian American communities experienced over 9,000 anti-Asian hate incidents, many fatal since this year and a half, but the increased focus on China as an enemy of the United States has increased the atmosphere of xenophobia and encouraged more violence. Worse, as this incredibly important and timely report shows, some of this prejudice is being led by our own government thanks to something started by President Trump called the China Initiative. The China Initiative, an effort to stop Chinese espionage in American scientific research, is unique among Department of Justice or DOJ investigations. Whereas most investigations start with a crime and then find a suspect, this initiative starts with a suspect based on ethnicity or national origin and then searches for a crime. Just family ties to China or even professionally encouraged research and collaboration can be enough to trigger an investigation. In fact, this initiative stands out as one of the only Department of Justice efforts named for a specific country. And so, as a result, simply doing research while Chinese could be enough to have your life and career ruined by a criminal conviction. This is more commonly known as racial profiling. This has real consequences for the way these investigations play out, with chilling effects for both the Chinese American community and our country as a whole. First, by looking specifically at Chinese scientists, we might be missing real instances of espionage from other countries. As former CIA Director Robert Gates said, there are probably a dozen or 15 countries that steal our technology. But only one country, China, has been deemed to require what FBI Director Christopher Wray called a whole of society response. This is the exact kind of language that leads to widespread mistrust of Chinese Americans. Second, this initiative prioritizes convictions, not justice. And that has too often meant bringing a case without sufficient grounds, something that has ruined the lives of people like Dr. An Ming Hu. Dr. Hu, a Canadian researcher working at the University of Tennessee, Knoxville since 2013, was accused of spying for China based on a paperwork filing error and the FBI's admitted lies. His case became the first case tried in court as part of the China Initiative, and the conclusion of it is incredibly telling. After the FBI agents involved admitted under oath to knowingly building their case on falsified evidence, the case ended in a mistrial. But the U.S. government shockingly said they intended to retry the case. Fortunately, earlier this month, a U.S. district judge rejected the Department of Justice's request for a retrial and completely acquitted Dr. Hu. While I am glad that Dr. Hu has been cleared, the damage has already been done. Already his career and reputation have been harmed, just as it is with other scientists and researchers like Dr. Xiaosheng Shi and Sherry Chen, who suffered personal and professional harm only to have the charges dropped completely. Additionally, these investigations have led to many young Chinese Americans deciding to avoid careers in science out of fear they too will be investigated or worse, and it is particularly dangerous amid rising anti-Asian hate crimes. All of these reasons demonstrate why the China Initiative must be brought to an end. There is a legitimate need for counter-espionage work in our government, but that work must be based on evidence and not race. And I'm optimistic that we can make this change because already, by speaking out, we have gotten the U.S. government to end a shadowy unit at the Department of Commerce that had been investigating mostly Asian and Middle Eastern employees based on their ethnicity without any oversight. When I heard about this unit, I immediately called for it to be disbanded, which is what the Department of Commerce, thankfully, has done. But there is still more we can do. In addition to ending the China Initiative and other similar programs, we must also stop the Cold War rhetoric. When the Chinese government acts against our interests or values, We can and must speak out, but we need to be deliberate in what and who we criticize. It should be those who are responsible, not all Chinese people. And we can't let fear become an excuse to rob Chinese Americans of their civil liberties. There are still those alive today who were forced into U.S. prison camps during World War II because it was believed that just being Japanese made them untrustworthy and spies. This policy was wrong then, and a policy of mass suspicion is wrong today. That is why this summer I and our KPAC leadership sent guidance to every member of Congress on how to speak out against China's policies without stoking xenophobia here. That means not spreading unfounded suspicions that paint all Chinese people as threats and which put innocent Chinese Americans at risk. Fighting this will take all of us working together, and your report will be invaluable in helping more people understand the problem. So I look forward to working with you on this and so many issues to ensure this continues to be an inclusive America where everybody is treated equally. Thank you.
Thank you, Congresswoman Chu. Next, the Committee of 100 President Zheng Guang will provide insights on why we conducted this research and why now. Z, the floor is yours.
Over the last year and a half, America has experienced a nationwide reckoning with race, where the killings of George Floyd, Breonna Taylor, and others has resulted in a movement and calls for change. Moreover, in 2020, anti-Asian hate crimes surged and Asian Americans were blamed for the COVID-19 pandemic and subjected to a string of violent and horrific hate crimes. What has become abundantly clear for the Asian American community is that one, our need to track data on racial profiling, discrimination, and hate crimes, and two, to push back against discrimination and hate wherever it may occur, especially emanating from our own government leaders. The Committee of 100 is pleased to present this important white paper, Racial Disparities in Economic Espionage Act Prosecutions, a window into the new Red Scare, jointly conducted by the Committee of 100 and legal scholar Andrew Kim, attorney at Greenberg-Traurig, visiting scholar at South Texas College of Law, Houston, and participant in Committee of 100's Next Generation Leaders Program. The study, which Committee of 100 and Kim co-developed over years of research, includes data from 1996 to 2020 and offers empirical analysis of U.S. government economic espionage claims. It is an updated and revised continuation of a previous study which was published in 2017 by Committee of 100 and Kim, Prosecuting Chinese Spies, an empirical analysis of the Economic Espionage Act, as well as in the Cardozo Law Review in 2018. This study is particularly important at this moment because it provides hard evidence that indicates a concerning trend of racial profiling in Economic Espionage Act prosecutions. It is important to consider the backdrop of these prosecutions. In recent years, the United States has devoted increasing amounts of attention and resources to countering Chinese espionage, theft, and hacking, most notably through the China Initiative, which started in November 2018. Although limited in scope, this study seeks to provide an empirical lens through which to begin to evaluate efforts such as the China Initiative and the phenomenon known as researching while Chinese. In addition to Kim's findings, this white paper includes a statement from Gary Locke, the chairman of the Committee of 100, and the first Chinese American ambassador to China, as well as 5 independent commentaries to provide further context to the study's findings. Please join me In exploring the topics discussed in this white paper and during today's discussions and panels as part of a larger conversation about race in our country and how together we can do our part in forging a better America.
Thank you, Z. Now please welcome Andrew Kim, attorney at Greenberg Tree, visiting scholar at South Texas College of Law, to talk about the findings of the research. Andy, the floor is yours.
Thank you, Ambassador. Thank you, Congressman, and thank you, President Tong. And definitely thanks to all of C100 for all of your support. The basic question that this study tries to answer is whether Asian Americans are treated differently with respect to suspicions of espionage. The answer to that question is yes. This study focused on the Economic Espionage Act. The Economic Espionage Act was enacted in 1996 to criminalize economically valuable secrets. Economic value secrets. Essentially, it criminalizes spying for financial gain. We analyzed PACER filings for each of these 190 cases. All the federal court filings, the indictments, the arrest warrants, bail decisions, and of course, whether the defendant was convicted, acquitted at trial, pled guilty, or the prosecutor decided to drop all charges. Now, economic espionage is a serious issue, and it affects Americans across the country, particularly in California, but also in Texas, Georgia, and Iowa. Anywhere there's a business, there are valuable secrets to steal. The government's been using the Economic Espionage Act with increasing frequency since it was enacted. There was a huge drop-off last year in 2020 in the number of cases brought, but that has a lot more to do with the federal courts being closed due to COVID than to any policy changes. Now, the media likes to focus on foreign espionage, but surprisingly, 42% of alleged spying in this study occurred for an American business. In those cases, the alleged spy stole secrets to be used for an American person or an American business that's usually a competitor of the victim. 46% of these cases allege spying for business or person in the People's Republic of China. Economic espionage affects all American businesses. High-tech, industry, and manufacturing are, of course, prime targets, but there's also spying that occurs in farming, the gaming industry, even in the pet food industry. Now, in recent years, the NIH, Department of Energy, and other governmental agencies have been conducting massive investigations into professors at universities. But this study found that only 3% of trade secret thefts actually occurred in academia. This is actually not very surprising because there's really very few secrets within academia. I used to be a professor myself, and I can tell you that your main job as a professor really is to publish. You come up with brilliant, earth-shattering insights, and then you beg the highest ranked journal you can to publish them for you, and they're going to publish them for free. Legally speaking, economic espionage can only happen if the secrets that you've stolen have economic value. It's hard for academic research to have economic value when the entire point is for you to share it with the world with no compensation. The government has been focusing on finding potential spies in academia, but this study suggests that the government is looking for spies in the places where they're least likely to find them. We looked at trends over time. Beginning around 2009, we saw a major shift in the demographics of the people who were accused of spying. Before 2009, the vast majority of people accused of spying were people with Western names. Only 16% of accused spies had Chinese names. But 2009 came and suddenly everything changed. Now, the majority of people accused of spying are people of Chinese descent. And proportionally speaking, people with Western names are half as likely to be accused of spying. The big questions this chart raises is, did Chinese Americans suddenly start stealing 3 times as many secrets as before? Or did the DOJ start focusing on crimes that have a nexus with China? And if the latter of the case is true, that the DOJ has just been focusing more on crimes in China, then by focusing on the crimes committed by defendants with Chinese names, do they start neglecting equally serious crimes that are being committed against America by people with Western names? I also wanted to see whether there were any patterns in the citizenship of people who were accused of spying. Almost all of the defendants with Western names were coded as US citizens. Half of the defendants with Chinese names were coded as US citizens, while the other half were foreign nationals, primarily Chinese, but with some Canadians as well. For non-Chinese Asian Americans accused of espionage, a third of them were foreign nationals, while 2/3 were US citizens. Key finding in this study relates to the final dispositions of cases. This is what happens to the defendant after they've been charged and accused of espionage. The vast majority of people charged and accused of spying are convicted of spying. A significant number of defendants are convicted only of fraud or other serious crimes, not spying, but still very serious crimes. 16% of defendants that are accused of spying are convicted of no crimes. They're either acquitted at trial or the prosecutors dismissed all charges. There's no judgment of innocence in our justice system. But because these people were never proven guilty of any crimes, they may have been innocent the entire time. A small number of defendants accused of spying were convicted only of false statements or other crimes that we call process offenses. These include crimes that might not have ever occurred if the defendant hadn't been wrongfully investigated for espionage in the first place. So, for example, the most common of these crimes is lying to federal investigators. And when you've been interrogated. When you've been interrogated by federal investigators and told that they suspect you of a crime, it's surprisingly easy for otherwise law-abiding citizens to lie to try to protect themselves. But once they do, that's the crime of false statements. False statements is a serious crime, but it's not espionage. So this study treats people who are accused of spying, but convicted only of false statements or other process offenses as possibly being falsely accused of spying. When we dig deeper, however, it turns out that this problem of innocence is really a story of race. Only 11% of defendants with Western names in the study were coded as possibly innocent. For defendants with Asian ancestry, the rates of possible innocence are more than double. As many as 1 in 4 people of Chinese or other Asian descent charged with spying may have been falsely accused. And when we remove foreign nationals from the equation, we see that the innocence problem is also quite serious for presumed American citizens of Asian descent. 1 in 4 Asian Americans charged with spying is never proven guilty of any crime whatsoever. When we include defendants who were convicted only of false statements or other process offenses, it turns out that 1 in 3 Asian Americans charged as spies may have been falsely accused. These numbers are significant and they're concerning. And they're very similar for Chinese Americans. Beyond innocence, though, we also looked at the punishments that people received when they are convicted of crimes. Now, nobody wants to be a federal felon, but as an attorney, I can tell you that what people fear more than having a felony conviction on their record is being incarcerated in federal prison. Half of defendants with Western names who were convicted of a crime received a sentence of probation only. They're all convicted felons. Many of them had to pay fines and restitutions, but half of them were able to go about their lives without spending any time in prison. The same cannot be true for defendants with Asian names. 3/4 of defendants with Asian names who were convicted of crimes were sent to prison. And only 1 in 5 people with Chinese names received a sentence of probation only. The rest of the defendants with Chinese names were sent to prison. Similarly, when we look at the sentence length, it turns out that the average sentence for Western defendants convicted of crimes was 12 months. For defendants with Asian names or Chinese names, their sentences were twice as long. We also found disparities in how defendants were informed of the charges against them. Now, movies and TV dramas, they love the perp walk. Now, that's when the FBI shows up and they say, Mr. or whatever, we have a warrant for your arrest. And then they slap the handcuffs on them. But it's great for TV, but being arrested is actually a really traumatic experience. The first time Dr. Shi of Temple University learned that he'd been charged with crimes was when the FBI pounded on his front door. They pulled out their guns in his own home. They handcuffed him and pulled him out of his home in front of his wife and his 2 young daughters. Sherry Chen was arrested while she was at work. She was handcuffed and marched out of her office and past her friends and coworkers and taken to the federal detention center. Being arrested is traumatic. And frankly, it's also really, really inconvenient. In the American justice system, you have the right to have an attorney. But if you've been arrested, how do you find a good attorney when you're in federal lockup and they've taken your cell phone? The DOJ has the power to skip the trauma and the expense of ordering a full arrest with something called a summons. That's literally a formal letter that they send ordering the defendant to appear in court to face the charges against them. Most defendants that I found with Western names received a summons ordering them to appear in court. This is a good thing. This gave the defendants an opportunity to find and hire a lawyer, lets them reschedule meetings they might have had on that day, and it gives them the time to prepare to minimize the impacts that these criminal charges are going to have on their lives. But the courtesy of a summons was not extended to the vast majority of defendants with Chinese and Asian names. Instead, 78% of defendants with Chinese names were arrested, generally with handcuffs. Defendants with Asian names were also denied bail much more often than other people. Now, when a defendant is denied bail, that means that they're going to stay in federal lockup until trial. So even though they haven't been convicted of any crime, the defendant is still going to be in prison for months. Our justice system presumes that defendants should be released on bail because none of them have been proven guilty. However, defendants with Asian names are 4 or 5 times more often than defendants with Western names to be denied bail. It's likely that people with Asian names are denied bail in part because judges, rightly or wrongly, are concerned that they may be a flight risk. And to be fair, many people with Asian names speak a foreign language, so they might find it easier to settle in a new country. However, this study suggests that the fears that people of Asian descent are more likely to jump bail and flee the United States are overblown. Out of 249 Economic Espionage Act defendants who were released on bail, only 1 defendant since 1996 has actually fled the country. That one fugitive was a Chinese citizen of Chinese descent. But there were 25 other Chinese citizens in the database who were released on bail and did not flee. The reason for why these flight rates are so low is actually pretty simple. Anytime a judge is worried that someone's going to flee the country, then the first thing they do is they order the defendant to surrender their passport before they're granted bail. And it turns out that's actually really, really hard for white-collar defendants to leave the country if they don't have a passport, especially if you're wearing an ankle monitor. Very importantly, no American citizen, native-born or naturalized in this study, who was granted bail has ever fled the country to avoid facing charges under the Economic Espionage Act. Now, this slide might be the most important one in this study. The Department of Justice issues press releases when they want American public to be aware of certain threats to America and to be aware of what the DOJ is doing about it. So what does it mean when the Department of Justice publicizes crimes by people of a certain race more than similar crimes by people of another race? The Department of Justice issues a press release in 51% of EEA cases that involve someone with a Western name. So apparently the Department of Justice only considers the alleged spying by people with Western names to be newsworthy half the time. For people with Asian, particularly Chinese names, the Department of Justice publishes press releases in 80% of cases. When the Department of Justice publishes certain crimes by people of one race more than the same crimes by people of another race, they risk unfairly racializing the threats that face our nation. This study shows that Asian Americans, particularly Chinese Americans, are being treated differently when they're suspected of espionage. Our US attorneys and FBI agents, however, are not racist. They're loyal, honest, dedicated, hardworking men and women who are risking their lives to protect our nation against legitimate threats. But there's this concept called implicit bias that's more about how we're taught to perceive the world than about any kind of racial feelings. The DOJ has worked hard to combat the threat of spying by the People's Republic of China, in part by raising the alarm of Chinese spies. They created an infomercial about how Americans could be spying for China. They issued press releases, and they even started an initiative by the name of the China Initiative. By promoting this story and this image of Chinese spies, the DOJ makes it easier for Americans to imagine that people who look Chinese are actually Chinese spies. Now let's look at this slide again. Since 2009, the majority of people accused of spying have been people of Chinese descent. But what happened? Is this because people of other races suddenly stopped spying on American businesses? Or is this because the Department of Justice has prioritized alleged spying that include a nexus to China, even if the only nexus to China is the race of the defendant that's been accused? Either way, numbers like this feed into the story that the greatest threat to America's economy is Chinese spies. A focus on the economic threat from the People's Republic of China can also explain why Chinese Americans are more likely to be falsely accused of spying. It could be that an overzealous rush to stamp out Chinese spies, the Department of Justice is inadvertently sweeping up innocent Chinese Americans. And that's why so many of them who are accused of being spies are not convicted. But if that's the explanation, then why are non-Chinese Asian Americans also more likely to be falsely accused? Could it be that, like Chinese Americans, all Asian Americans are subject to the perpetual foreigner myth? Or maybe more directly, in terms of these implicit biases, could it be that people like me who look Chinese enough to look like the Chinese spies that we've been taught to fear? The People's Republic of China is one of America's greatest trading partners and one of its greatest economic rivals. However, by underreporting spying by people with Western names and overreporting the same crimes by people with Asian names, gives a distorted impression of the actual threats to America's economy, both foreign and domestic. Last year, the US Attorney for the District of Massachusetts said, and I quote, "You want a little bit of fear out there to sensitize people to the magnitude of the problem." Although these comments were intended in the service of our nation, I believe that they are misguided. If we want to protect America's economic interests and fulfill the promise of equality, we need to address the threats against our nation based on facts, not on fear. Thank you.
Thank you, Andy. Next, we'll have the first of our two panel discussions. First, we'll focus on US scientific leadership at the crossroads. That panel will be moderated and led by Frank H. Wu, President of Queens College and Committee of 100 member. Joining Frank will be Ashley Gorski, Senior Staff Attorney at the ACLU's National Security Project, and Margaret K. Lewis, Professor of Law at Seton Hall University. Frank, the floor is yours.
Good morning, everyone. What an honor to be here for this important conversation. And there's so much in the work that Andy Kim has done. So many thanks to Andy. And I want to pick up on a thread of his commentary, which is no one here is saying that either federal prosecutors or law enforcement officials are bigoted. That's not the claim at all. It is instead the claim, as with the COVID-19 violence against Asian Americans, that there's a pattern. That even if you don't know in any particular case that anyone was what we might deem racist, that this is racial, that there's a racially disparate effect at work here. So let's go ahead and get started about the general climate at American institutions of higher education. As Andy mentioned, so much of the investigative effort has been focused on universities where research is conducted. Why don't we start with what the climate is like there? Maggie, you've written about how China has been criminalized. Maybe you could explain that concept, that any contact with China is now regarded as problematic. Maggie?
Well, thanks so much to the organizers for having this event and for everyone who worked on the report, and particularly Andrew, and thank you, Frank, for moderating. So I've been really concerned about economic espionage even before the China initiative, and this idea that people do so easily get othered. And the more that we learn about how the brain works and implicit bias, conscious bias, that even if we have well-meaning law enforcement officers and prosecutors, that they can get drawn to people with certain characteristics when there is a framing about what their job is supposed to be. And so here, I have long studied China. I am not a scientist. I am someone who's a law professor and I work on human rights. But I've spent a lot of time in the last few years speaking with people who are scientists and particularly are either Chinese nationals still, or a lot of Chinese Americans, whether here by birth or naturalized citizens. And I gotta say, the mood is scared that, even just a handful of years ago, you had universities encouraging collaboration with Chinese universities, trying to get more students over there from the United States. Relations might have been strained, but there was an understanding that there should be this connectivity. And since really the China initiative has brought to the fore this emphasis on saying that research security is paramount and that we're going to have this chilling effect that is intentional. And so you have these high profile cases that really have made people feel, should I even leave the country? And we're starting to see that, in addition to drying up, or at least really putting the squeeze on the pipeline of talent coming to the United States. And so, overall, I get there's this, sort of short-term, devastating impact on the lives of people directly impacted by these law enforcement efforts. But also, this is an issue really of long-term academic vibrancy and U.S. economic competitiveness.
Thank you so much. Ashley, you're with the ACLU and you work on national security. You're an expert in this area. How does this set of issues fit with the more general work that you're doing on national security and the mood on campuses? What's going on here?
Sure. So first of all, thanks to C100, to Andrew, and to Frank for moderating. It's a pleasure to be here today. I'm a senior staff attorney with the ACLU's National Security Project, and I think your question, Frank, prompts a real problem here, which is that many of the academics who are being prosecuted for disclosure-related crimes. And at the end of the day, these crimes are more properly addressed under a framework of research integrity as opposed to a national security issue. At bottom, a failure to disclose information does not in and of itself present a national security issue, particularly in the vast majority of prosecutions that we've been seeing under the China initiative. And I am not an academic, so I'm not currently on a campus, but at the ACLU, we've been closely monitoring prosecutions against Chinese American scientists. We've been involved in some of these cases. We fielded intake calls from affected academics. And based on those experiences, based on media accounts, what Maggie's saying is entirely correct. And I just want to echo and amplify it. I think that there's a climate of fear and chilling effects. There's concern that anyone of Asian descent may be unjustly targeted for investigation and prosecution. There's fear that international collaboration will be taken out of context. There's fear that ordinary clerical errors may become criminalized. And in addition to that fear, I think there's also frustration that many universities have not done enough to protect their professors. And you really do have this sea change where historically, so many of these issues would have been dealt with at the administrative or institutional level. If a researcher didn't fully disclose that he was receiving grants from a Chinese institution, that's a matter that traditionally would have been addressed by a university employer or a government agency. And instead now you have academics being charged with serious crimes. And I think relatedly, there's been a change in how participation in foreign talent programs has been viewed. Historically, again, that was encouraged because universities wanted to see stronger international ties and international collaboration. And now, as just one example, you have an FBI agent recently testifying that a professor came onto his radar because he was involved in the Thousand Talents program. So it's now being viewed as inherently suspicious. And all of this has significant chilling effects and long-term consequences, and leads and will lead many talented scientists to leave the United States or discourage them from coming here in the first place.
That's right. So ironically, it could create a self-fulfilling prophecy where there's a fear that China is advancing, but this effort may drive talent back to China or keep talent from ever coming here. Let's talk about what it's like on campuses. Maggie, you are yourself a professor. Why the emphasis on institutions of higher education here? And how have the universities been responding? It seems as if there's quite a wide range, with some institutions, to use the vernacular, pushing the scientists under the bus, while others, we've seen professors organizing on behalf of their peers. So Maggie, why higher education, and what's going on with universities?
Well, the direct answer of why higher education is there's a lot of government money that goes into higher education, a lot of grants from National Institutes of Health. We've had NASA grants, National Science Foundation. And so these are oftentimes, we're here not talking about the economic espionage charges, the attempted or actual theft of trade secrets or valuable intellectual property, but rather this much bigger ball of potential, really serious felony charges that Ashley is talking about for false disclosure, that failing to either disclose a relationship with a PRC-based entity, wire fraud, that there was money that's changing hands and it's going through, and then you haven't disclosed your relationship that was necessary as part of that grant. And so that whole, there's a lot of money that goes through these universities. So that's why I think we're seeing it. And there's a lot of really cutting edge research, not classified research. That's not what we're talking about here. This is this basic research, and the reason the U.S. is such at the forefront is because we really value collaboration, value putting information out there and having that open science model. And with that comes some vulnerability. So I want to be clear that questioning how to enhance research security is a valid inquiry, but it should be done in a country neutral manner, because guess what? People from other countries steal things too, right? This is not just about China stealing things. And in fact, when you look at the China initiative, oftentimes China is talked about as something that has hands, like it's this anthropomorphized, what is China's malign behaviors? China is stealing things. And that alone feeds that existential threat rhetoric. Now, on the positive side, we do have in particular these tensions that often emerge between the faculties and the administrations. We've seen people be fired with concerns about the process or lack thereof that's occurred. There's times like with Professor Gang Chen at MIT, where MIT is paying his legal bills, but that is really the exception to the rule, as he is going through his case right now. We're seeing more concerted action. Stanford, we just had 177 faculty members at Stanford send a letter to the Department of Justice, to Merrick Garland, saying it's time to end the China initiative. This is, working against the purposes that you really want to achieve of a strong US. And we're also starting to see letters like that bubble up from other universities. So stay tuned. I think we're going to see a lot of those that are similar to the Stanford letter in the days and weeks to come.
That's great. Thank you. Ashley, what's your sense of academic institutions, the importance of international collaboration and balancing the scientific norms with all of these issues?
Sure. So, as Maggie was saying, there certainly are valid concerns about protecting IP from trade secrets theft, concerns about espionage, but that these concerns are not country specific, or they shouldn't be country specific. And so I think the point that really bears emphasis here is that research security is not about a single country, and it should not be just about China. And I think step one is setting aside this China-specific framework, which produces discriminatory and biased results. And in terms of how universities should approach this going forward, there's an independent advisory group of elite scientists known as Jason. I'm sure this is familiar to many people watching today. And they put together some guidance for the National Science Foundation a couple of years ago. And I think that guidance provides a helpful roadmap. Their key recommendation is that the umbrella of research integrity be expanded to include full disclosure of commitments and actual or potential conflicts of interest. And so that when there are failures on that front, such as a failure to disclose a funding source, those failures would be dealt with by the grant-making agency and universities as a presumptive research integrity issue, not as a crime. And the government, universities, and professional societies also need to ensure that the responsibilities and standards for research integrity are clear, are acknowledged, and are actually adopted. There needs to be more in-house training at institutions, more guidance, and more expectation setting. I think in addition, something that was flagged in the Jason report that's worth mentioning is that responsibilities and standards should ideally be harmonized across government agencies, because right now, reporting requirements are really a patchwork. Agencies are not consistent in their rules and requirements for grant applications. And that kind of harmonization at the federal level would go far toward improving transparency and improving compliance. And then finally, government agencies need to actually understand the importance of foreign researchers and collaborations to US fundamental research. There is a very long history of foreign-born scientists and engineers working in this country, and it's essential that the US continues to attract and retain global talent. And I think beyond the Jason report recommendations, other commenters have suggested an amnesty period in which academics could come forward with information about their associations and relationships and not face any kind of criminal penalties for doing so. And that seems sensible to me.
Thank you, Ashley. Yes, there have been so many, my own parents, for example, who constituted brain drain and contributed to the U.S. economy, eventually becoming green card holders and then U.S. citizens, and then their children being born in the United States, as I was, becoming native-born Americans, no different than their neighbors or co-workers. Maggie, you're writing about criminalizing China. You've pointed out also that it's not just people of ethnic Chinese descent. Contact with China appears to be producing problems. So even if you're white, Anglo-Saxon, Protestant American, if you've been involved with China in some way, would you talk a little bit about this atmosphere of anxiety and fear? How much should we think of China as a threat or an ally or a competitor? And what do you mean by criminalizing China? You've documented this effect. So tell us a little bit more about that.
Yeah, thanks. So Representative Chu mentioned that it's highly unusual, if not unprecedented, to name a Department of Justice initiative after a country. We've had initiatives for against crack cocaine, against human trafficking, against a lot of different kinds of crimes. But to label it as the China initiative, we haven't had a Russia initiative, Canada initiative, whatever it might be. And then, it comes to this question of what do you even mean by China? And so we're seeing here, and this comes out in the report being released today, and that was just discussed in the findings, that part of this is about nationality, that people who are from the PRC, and that the xenophobic aspect is in there, but also about prejudice based on ethnicity, that someone who, even if they are American and might have spent their entire lives here, that somehow their connectivity of being of Chinese descent seems to add to this level of suspicion. And the reality is that universities were leaning heavily on their faculty who had the linguistic ability and the cultural competency to build those bridges in China. So it was no surprise that the people who had the most contact oftentimes were those who had some sort of heritage ties to China. But it goes further than that. And so we'll see things like in press releases, even if it's been someone who looks like me, that it will mention things like, and he speaks fluent Chinese. And these press releases aren't that long, and somehow it's seen as relevant, that it's more suspicious that you somehow have had this connectivity. And I'd say on a personal level, I first went to Beijing in 1995. I'm currently in Taiwan, so very different situation, but I've spent a lot of my professional life working with Greater China. And I have never seen an atmosphere where this idea of having any engagement with counterparts in China is seen as somehow that you're soft on China, or that you're not holding up for the US interests. And that sort of general sense of having the desire to communicate with people from a nation that is a near peer competitor, but to have those contacts somehow makes you somehow suspicious is really, I think, a disturbing trend that goes so much further than what we're talking about today.
Ashley, when the ACLU is involved with this, you're advancing broader principles that you stand up for. How does this work connect with what the ACLU is doing in the national security area and with the concerns that you have and the other work that you do?
Sure. So in the National Security Project, one of our strategic objectives is to put an end to policies and laws that are enacted or promulgated in the name of national security that are discriminatory in their impact or their intent. And I think it's very clear that the China initiative has had a discriminatory impact, certainly. And so the China initiative, purports to be about national security. I think at the end of the day, when you're looking at these prosecutions, there's a real question about the extent to which they fit within that national security paradigm. But because the government has cast this as a national security issue at the ACLU, it falls within our mandate, and it falls within the work that we do to ensure that individuals are treated equally under the law.
Thank you. And we're almost out of time, so let's wrap up and turn to what lies ahead. The past few weeks have seen just a stunning series of setbacks for the federal government. The Anming Hu case ending in a mistrial, and then the judge dismissing it outright. And if you look at what the judge wrote, it was really quite firm. The judge said that the legal theory was flawed. But even if the legal theory were accepted, the government didn't have evidence to make out its case. There were also half dozen other prosecutions that were dropped. There's the bombshell report that the Commerce Department had a rogue unit that was investigating people of Asian descent and Middle Eastern descent based on their surnames. The Commerce Department has announced that they will close that unit. And just a few days ago, the Washington Post published a major article looking at the China initiative, quoting 3 former federal prosecutors, all of whom said that the China initiative had gone too far, and maybe it's time for an amnesty or some way for folks to come clean about the connections they have where it might not be criminal. So there really has been, just in the past few weeks, a change in the public attention to these matters. So why don't we start with Maggie and then turn to Ashley. Where do you think this is headed? Is the China initiative about to end? And how has advocacy been a part of that? How can we be effective, those of us with these concerns, in making our voices heard? Maggie?
When it comes to actually making a prediction, I'm going to go with Yogi Berra's. It's hard to make predictions, especially about the future. I'm not going to try to put myself in, in the halls of Main Justice and think what's happening there at the National Security Division and at the highest levels. But I will say that, totally, there has been an increasing momentum to show that the China initiative is just fundamentally problematic. And I think Ashley's point is so important, that it's about impact, not just about intent, that you can have totally well-meaning investigators and prosecutors who really believe they are just following the evidence. And in fact, their brains could be taking them to people whose last names are Wang and Zheng and Hu more without them even realizing it. And so I don't want to sound like we're saying that they're not doing their jobs or think they are, but we need to just take a step back and realize that no matter how well you try to do the China initiative, it is flawed from the start. And we need to get a better sense of collaboration with people outside the government who are experts in not just implicit bias, but also about issues about research security. As mentioned too, there's been these reports with the An Menghu case and others that the investigators involved did not have a firm grasp on how even the grant process worked. How could they be doing the job that needed to be done to understand a NASA grant if they did not have that training that was required? So I think there's so much work to be done there. I am hopeful that the dropping of several cases, Qing Wang case and the visa fraud cases, shows that there is at least a case-by-case look going on in the DOJ. What we haven't seen is that pullback to this broader decision to question the overall framing. I'm still hopeful. I'm an optimist by nature. So I think we need to think in terms of keeping this pressure up, and that hopefully ultimately will have the Biden administration, which has been saying again and again, they're against xenophobia, they're against prejudice, and that they want to do the right thing when it comes to supporting people who are of all ethnicities and races, that we need to actually see that talk turn into action.
Ashley, we'll give you the last word. You work very directly as an advocate. So what is effective advocacy here? And how could people partner with the ACLU or others, those who are concerned, who are attending this? How can they bring about this change? Ashley?
Sure. So as Maggie's saying, we absolutely need to keep the pressure up. And there are many organizations that are working on advocacy related to these issues. C100 is one of them. The ACLU is pursuing a Freedom of Information Act request with Advancing Justice AAJC, which has also been a leader in advocating on this set of issues. APA Justice, there are so many organizations. I hesitate to start listing because I don't want to exclude someone, but there are many organizations on the ground advocating in a variety of ways, encouraging people to call their representative, call their senator, organizations putting together letters to various government agencies. And so I would encourage people to get plugged into those organizations. The advocacy efforts are ongoing and they are essential. And it's also essential that we not just see a change in nomenclature. I think that it would be very easy for the Biden administration to say there is no more China initiative, but for this underlying framework that Maggie was referring to remain in place. And so I'm very hopeful that these advocacy efforts will lead to meaningful, lasting change and a real shift in this framework that's been so problematic and so devastating for individuals of Asian descent in this country.
Thank you so much. I'll turn it back over to the Committee of 100 hosts. Many thanks to scholar Andrew Kim for all of his work, the rigorous statistical work documenting this very real effect, that there are disproportionate prosecutions, different treatment throughout the process, lengthier sentences, that even if you can't prove it in any one case, when you look at the pattern, boy, it just jumps right out at you. So thank you so much to our panelists, Maggie and Ashley. Back to the C100 hosts. Thanks.
Thank you, Frank. And let us also say thank you to Ashley and Margaret as well. The next panel discussion will focus on unequal under the law, balancing civil liberties and national security. And it'll be moderated by Nelson Dong, partner and head of National Security Group and co-head of Asia Group at Dorsey and Whitney and a Committee of 100 member. Joining Nelson is Congressman Ted Lieu, who represents California's 33rd Congressional District in the U.S. House of Representatives, William Tong, the 25th Attorney General to serve the great state of Connecticut, and Carol C. Lamb, former United States Attorney for the Southern District of California. Nelson, the floor is yours.
Thank you very much, Charles. And I join everybody else in welcoming our very distinguished panel members, Carol, Ted, and Bill, as they appear on my screen. Since we have limited time today, I'm going to jump right in with a couple of questions for our individual panel members, and then we'll go through some group questions that we'll hear answers from all three panelists. If I might, Congressman Liu, begin with you, since you've been long involved in these congressional hearings and oversight of the China Initiative and programs like this across the federal government. What conclusions have you and your colleagues in Congress learned from your most recent oversight efforts about these programs?
Thank you, Nelson, for your question. And I want to thank the Committee of 100 for putting on this important event. Through oversight and hearings and letters and other actions we've taken in Congress, we're trying to put pressure on the Department of Justice to really take a look at the China Initiative and make some fundamental changes or eliminate it. What we do know is that there have been multiple cases, including high-profile ones, where the Department of Justice simply got it wrong. They wrongfully accused Wen-Ho Lee of spying for China. They wrongly went after Sherry Chen. They wrongly went after Professor Xi. And recently, Professor Aming Hu was acquitted. And when you look at this, if it was just one case, maybe that's a mistake. But when you have multiple cases, then it becomes a pattern. And this data from the Committee of 100 and the research report is really important. And from our oversight hearings, it's very clear to us that the Department of Justice is engaging in either conscious or unconscious racial profiling or ethnic profiling. And that's why we really need Merrick Garland and his leadership at Department of Justice to take some strong action. We do have a agreement to have a meeting with Attorney General Garland on this very specific issue. And we're trying to schedule it so it works for all of us, and, which is going to be the Department of Justice leadership, Merrick Garland, as well as the Asian Pacific American members of Congress. And we'll report back to you after that meeting.
Well, I'm sure all of us in this audience will be very interested in the outcome of that meeting. I know many Asian American groups have sought those meetings with Justice Department officials and look forward to the feedback that you get. If I can turn now to Carol, who was once a very long-serving assistant U.S. attorney and then the U.S. attorney for the Southern District of California based in San Diego. Drawing on those years of experience, do you think that a directive like the China Initiative can actually shape and guide investigators and prosecutors in the field? And if so, how is that effect played out? And do you think it's having that kind of effect here?
Yeah, thank you for that question, Nelson. Yes, I do think it does shape and guide what investigators and prosecutors do. And yeah, I'll be honest, I'm not going to go easy on the Justice Department on this one. I think this was a terrible misstep on their part. I'm deeply disappointed in it. And you know, for this reason, I've never been a fan of criminal justice initiatives like this, or I should say criminal prosecution initiatives. I think there's a misalignment between the word initiative and the nature of criminal prosecutions. Criminal prosecutions are very individual decisions that have to be made based on the evidence. And once you combine it with something called an initiative, you end up with what we have here, which is decisions being made that are not based solely on the strength of the evidence or the merits of bringing a case, but it's, you know, what we're seeing is something that's designed to give credit to agencies and offices and individual investigators and prosecutors. It's a bad idea, and the way it's been executed here is particularly bad. What happens with initiatives is two things. You get cases that are brought that perhaps should not be brought on the merits, and you also get cases that are smaller and smaller and smaller and disingenuously put into the bucket of fulfilling the initiative for purposes of statistics. So as I said, I'm not going to go easy on the Justice Department on this one. I think this has been a terrible failure.
Well, I'm glad you held your punch there, Carol, in giving that grade to the Department of Justice. Let me turn now to Bill Tong, who is the Attorney General for the state of Connecticut, one of the great concentrations of technology and industry, home to many great companies like United Technologies and others, as well as home to great universities such as University of Connecticut and Yale, my own alma mater, and Carol's as well. Bill, one of the nominal goals of this China initiative has been to protect American intellectual property from theft by China. And from your standpoint, as a long practicing private practitioner in corporate law and litigation, as well as your more recent duties as the state attorney general, are you able to give us some sense of whether that kind of criminal activity is actually happening in Connecticut, which would otherwise seem to be a very big, rich, target-rich environment for such activity?
Well, thank you, Nelson, and thank you to C100 for hosting us. It's great to be with Carol and Congressman Liu. Let me agree with Carol and Congressman Liu and go a step further. The China initiative is not just a failure, it's an attack on Asian Americans and Pacific Islanders, an attack on Chinese Americans, and it puts a target on all of our backs, frankly. Yes, of course, particularly in a place like Connecticut, where there's a significant amount of defense contracting, technology, development, and commercialization, economic espionage, and America's competitiveness are important considerations and they're a priority. But we have a lot of competitors. We just saw last week the French are really upset that we're selling submarines to the Australians. Many of those submarines are made in Connecticut. The English are our competitors. The Germans are our competitors. But there's no German initiative. There's no Russia initiative, as a previous panelist said. There's only a China initiative, which is obviously a program and initiative to racially profile people. When Congressman Liu mentioned Wen-Ho Lee, Sherry Chen, Professor Shi, those names seem new and fresh in our memory and recent, but I want to remind everybody that there's nothing new about the China initiative. And in fact, many of the seminal American constitutional law cases about racial profiling and about selective prosecution are about Chinese Americans. Yikwo versus Hopkins, 1886. Asin versus Whitman, 1905, right? We're going back more than 100 years. And those are cases in which local or state governments enforce laws in a discriminatory way, quote unquote, facially neutral laws, which should apply to everybody, but they only enforce them against Chinese Americans. And so this, frankly, the American legal firmament around protecting people from initiatives like the China initiative come from cases and law developed in the context of Asian Americans and Pacific Islanders, and specifically Chinese Americans. Let me just close by saying, I said earlier, initiatives like this put a target on our backs. I mean it. This initiative and the language and the sentiment of initiatives like this make Asian Americans and Pacific Islanders unsafe and directly contributes to the spate and rash of anti-Asian hate and sentiment and attacks. And we should not be surprised when, under the auspices of the federal government, we launch an initiative targeting one group of people that people then get hurt.
Thank you. So let me open up with a question to all of the panelists, and if you could each respond in turn. Based on the things all of you have originally said in your opening answers, it seems to me you would agree with the proposition that the China initiative, as it's been cast by the previous administration and as it's being conducted today, has a kind of an inherent danger of institutionalizing racial profiling and ethnic profiling just by its very existence. Is that a fair way to put it? Ted, do you want to begin with that?
Sure. Let me sort of follow up on what Bill Tong said. The China initiative is not unusual in its design, right? We have had entire history of discrimination against Asians. We had the whole yellow peril hysteria, followed by the Chinese Exclusion Act. The entire Japanese American internment was based on the false notion that somehow Japanese Americans were going to be disloyal. So when you look at this, it is basically a very similar kind of thinking that our country's been engaged in for a long time, which is that somehow Asian Americans are disloyal, that we're not Americans, we're foreigners, we're second-class citizens. And just by its very design, I think it will lead to either conscious or unconscious racial or ethnic profiling.
Carol?
Yeah, I mean, I guess I go back to my original point, and I agree that, you know, unfortunately, what FBI Director Chris Wray has done, and I think Chris Wray is a good person. I just think that if he didn't initially realize what his statements were going to do, he should know it by now, that by saying this is a whole of China issue and, you know, your neighbors may be, you know, essentially spying because their relatives are being pressured in China, you know, to cast that sort of exceedingly broad net in the context of criminal enforcement is a very, very dangerous thing to do. And I'm surprised, frankly, that the FBI and DOJ did not recognize that when it was happening. And look, again, I'm very protective about the criminal prosecution realm because that it is different in nature from anything else. And I take great objection and offense to the fact that even in their failed prosecutions, even when prosecutions have to be dismissed by the judge or dropped by DOJ because they are lacking evidence after indictment, that what we hear is, well, the China initiative is working because more than 1,000 researchers have returned to China voluntarily. That is offensive because we don't know why those people went back. And I suspect it's largely because they are afraid of being, you know, unjustly targeted by this government. So to say that this sends a message and therefore it's doing something good, that's not how we use our criminal justice system. We don't accuse people in the hopes that we will send a message to other people against whom we have no evidence. So that is my objection.
Bill?
Well, I can't agree more with what Carol and Ted have said. Several months ago, I held a national convening on anti-Asian hate in which Congressman Liu participated by video. And much of what we learned from that day-long conference where we convened advocates, lawyers, elected officials, community leaders, is that initiatives like the China Initiative contribute to a culture and a climate of hate and targeting. It's not just objectification, it's not just otherizing. These are words that we've learned to use, but they really put people at risk and in harm's way. And as I said before, let us not forget that 6 Asian American women were murdered in Atlanta and from New York to California and many points in between. People are beaten, harassed, and some people have lost their lives. Let me just also say there's a temptation to think that this happens to other people, even though they may look like us, to academics, people who are recent immigrants from Asia or from China, and they work in some research facility. I think if you think hard about it, this targeting happens to all of us. You know, I'm the Attorney General of the state of Connecticut, an elected constitutional officer. I am routinely on social media accused of being an agent for the Chinese Communist Party. I've been called the Manchurian AG. When I was elected, I was called Kim Jong Tong. You know, this happens every day. And if it happens to me, right, and don't worry about me, right? I've got a staff and the team, and I'm going to be okay. But this happens to everyday citizens, our neighbors, our friends, our family, walking around on the street, and as we've seen, it makes them very unsafe.
One of the key findings that was reported on earlier this morning was that statistically it appears that Asian defendants are more likely than others to be denied bail. Now, all of you have spent time in the courtroom. Congressman Liu, as a JAG officer, Bill, you've been a career litigator, and Carol has as well, especially in the federal courts. What are some of the factors that influence that kind of outcome and produce that kind of statistical result? What is going on that creates that disparity? Ted,
I
if I
could
might
talk
come back to you.
about bail for hours and hours. I actually have legislation on bail reform. I actually think that it's stupid to tie money and cash on hand to whether a person's freedom is denied. I think we should eliminate, frankly, cash bail and go to a risk assessment system the way that Kentucky and Washington, D.C. have done. But I do digress. On this specific issue, I think it goes back to the same sort of implicit or unconscious bias that judges may have, that when they look at someone that looks like you or me, they think we're suspicious, that we're foreigners, that we're somehow not loyal to America, that because we can't trace our lineage to the Mayflower, that somehow we're going to, commit treason. So I think that probably plays a part in it. Without looking more at the actual cases and the details, it's hard to know exactly why judges would be making these bail decisions, but that'd be my suspicion.
Yeah, I agree, of course, with Representative Liu. I think that the legitimate legal reason is risk of flight, right? And this was addressed earlier in this session, that well, you take the person's passport away, and that does a lot to mitigate the risk of flight. I do think there's a lot of unconscious bias there, but I think there's also this feeling or suspicion that these folks are crafty and they're smart, and maybe they'll find a way to destroy evidence or manipulate the system somehow that will make our case harder to try. I think keeping people in custody for months and months and months on what is essentially a white collar accusation is very unusual when there's no risk of harm or violence, physical violence that will happen. So I do think there's quite a bit of unconscious bias there.
Sorry, it's only been a year and a half of this. I think we've got to be better advocates. You have four lawyers, but the panelists, all three of us are lawyers. We need to make sure that people who are accused and targeted have effective legal representation. If they're targeted in a way that establishes a pattern or a practice of targeting Asian Americans or Chinese Americans, then civil rights enforcement, law enforcement officials like me, state attorneys general, have to come together and figure out whether there are facts in the law to support a civil rights action in the appropriate case. I think we've got to go to our friends in the Department of Justice, and I know we've thrown a lot of heat at the Department of Justice today, but I just helped Vanita Gupta, an Asian American woman, become the #3 official at Justice. Kristen Clark is head of civil rights, and she was at the Legal Defense and Education Fund. I think if they were here today, they would be against racial profiling and they would be supportive of our community. But we have to demand of them that they take action then, right? We support them and we need their help here. And one idea, I think, Ted, when you have a sit down with justices, it seems to me they should have a special layer of civil rights review anytime they bring an enforcement action to affirmatively try to confront whatever bias there is in that action before they take action. So that's one. We need nuts and bolts changes and solutions. And frankly, it does us no good to complain about it, right? We need them to make changes so that we can protect people.
Let me turn to another perspective, I suppose. All of us have served in government at various levels. All of us have had a chance to look at this China initiative and then have heard the findings today. If you could be a philosopher king or queen for the day and you could wave your magic wand, what would you change? Would you simply to eliminate the program entirely? Or are there elements of this initiative that are worth retaining but modifying? And I think, all of us are going to have opportunities potentially to sit down with the Justice Department. Congressman Liu has already asked for such a meeting, but at such a meeting, what would you raise? What would you suggest be changed? Ted?
I would do two things. Under the Obama administration, when it became clear that DOJ folks had wrongly gone after Professor Xi and also Sherry Chen, we met with Department of Justice officials, including then Attorney General Loretta Lynch. We did press conferences, press releases, worked with civil rights organizations, including Committee 100. And she made a couple of changes. She added another layer of review in Washington, D.C. For espionage type cases. And she also ordered implicit bias training for all Department of Justice personnel. And to us, that was a recognition that they understood there was something going on when the defendants happened to look like you or me. Unfortunately, under the Trump administration, they did not carry out that training. So the first change I would have is have Attorney General Garland carry out the training that Attorney General Lynch had directed be done. And then second, I would in fact eliminate the China initiative. We don't have a Russia initiative, right? I don't think it's useful to have an initiative focused on a country when it can lead to racial and ethnic profiling. And then my final thought I had is I want folks to understand that public sentiment is everything. I think Abraham Lincoln had it right when he said, in fact, that public sentiment is everything. With it, nothing can fail. Without it, nothing can succeed. Understand your power to help shape public sentiment. So everyone watching this, if you would say things on social media or write to Department of Justice, or if you served there before, call some of your colleagues. When 170 Stanford professors wrote a letter to Department of Justice saying this China initiative is harming intellectual creativity and having the US attract the best and best professors, that was very helpful. So think of what you can do to let the Department of Justice know that they are doing the wrong thing.
Carol?
So, I'm not in a political position, and so I'll talk technically about the Department of Justice. They are where they are now. You might say that they should have run this program differently, but they now know that a lot of mistakes have occurred. And one of the things that I think has happened is that you have investigators, FBI agents, who there are two problems in the vast world of science. The FBI agents who are not typically trained in the sciences don't necessarily know what they're looking at when they're talking about espionage. The other problem is FBI agents are typically used to working with industry and concerns about theft of trade secrets and such, and they are unfamiliar with the atmosphere in universities with respect to open research. And so there needs to be training between the universities and the FBI so that there's a better understanding on the part of investigators what happens within the university context. Another problem is that the FBI, they want to work in secret on these cases. So they don't talk to a lot of people about what that university atmosphere is and how it could have led to some of these misunderstandings. Now, on the university professor side, I think that there are situations where, some may have not wanted to disclose income for tax reasons and such. Yeah, they have to be a lot more careful about that because, a tax issue is not the same as an espionage issue. But when the FBI can't find the espionage issue, they'll go to the tax issue. So a lot of these things have to be sorted out in the DOJ. And that's what I think should happen right now, given where we are.
Bill?
So I think you asked a philosophical question, so let me answer it this way. I think the enduring problem is that Asian Americans and Pacific Islanders are invisible, largely in the halls of Congress. We have Ted Lieu, when a generation ago We had Bob Matsui and not much more help than that. But now there are 20-something members of the Congressional Asian Pacific American Caucus. So we're much more visible than we were, but we're not there yet. In this national conversation now about race and racism, Asian Americans are routinely left out of that conversation, overlooked. People question whether we even count as a minority community or a community of color or an immigrant community. And I think what we have to do is we have to support and empower people to speak up and to exert influence in rooms where decisions are being made. And we've talked about this for a long time. At C100, we've talked about it for a long time. I think if we're honest with ourselves, we're behind, not on schedule in this regard. And the reason why I think we struggle even now to get this China initiative eliminated, canceled, goodbye. Someone needs to stand up and say, this was a mistake, it's wrong, it's over. Is there any doubt that if this happened to any other community, that it would be gone in 24 hours? No, there's no doubt, right? But because it's happening to us, and because we lack political power and juice on a large scale, it persists. So we have to stop accepting the invisibility of being Asian Americans and Pacific Islanders and push really hard to make sure that people understand we're Americans. We're as American as anybody else. I was born in Hartford, Connecticut, you know, and I have as much a claim to this country and its promise than anyone else.
Let me ask if any of you have a final thought about sort of the human cost of these cases, even where a professor or a scientist in industry may be acquitted at the end. Most of them have had to pay for private defense counsel out of their own family savings. Their careers may be wrecked and severely damaged, as happened in the case of Professor Shi. Is there some governmental mechanism that would allow some redress to be made for these people who go the whole 9 yards and end up being acquitted? Is that proper to consider as a governmental duty? Ted?
That's a very interesting question. There are governmental programs that do provide compensation for people who were wrongly convicted and serve prison time. I'm not aware of one where you're charged and go through the entire process and then later you're acquitted. But it's an interesting thought. And so I will look into it now that you've raised it. These folks have suffered enormous financial difficulties because of these cases. Their reputation gets smeared. And so it is very, very hard on these folks who are falsely charged.
Yeah, and I'll add, I should have gone back and looked at the Hyde Amendment, which is the mechanism in federal court to bring a lawsuit against the government with respect to criminal cases that may not have been merited. But like Representative Liu, I'm a little uncertain right now whether there has to have been an acquittal in the case or whether it applies to charges that are dismissed. But I will say, regardless of what the standard or the mechanism is, it was very, very difficult to prevail on such a claim. Basically, the courts look for, if the government was able to hang its hat on something with respect to justification for bringing the case.
Yeah,
we're just about out of time, so why don't you wrap us up?
I agree it's really hard, but that doesn't mean we shouldn't try. And, the more we speak up and the more we put pressure, the more likely it is that people can be made more whole when they're victims of targeting and racial profiling.
Well, on behalf of the Committee of 100 and all the members of the audience, I thank our three distinguished panelists, Congressman Ted Lieu, Attorney General William Tong, former U.S. Attorney Carol Lam, for their comments and their wisdom today. We're very grateful for their participation in this Committee of 100 program, and I'll turn the microphone back. Thank you.
Thank you, Nelson. And let us thank also as well Congressman Lieu, William, and Carol for a tremendous job. And now for some brief closing remarks, turn the floor back over to Z. Z, the floor is yours for some final comments.
As we conclude today's event, on behalf of the Committee of 100, I want to thank everyone involved. I want to thank Andy Kim for collaborating with the Committee of 100 on this joint research project, and for presenting the findings today. I want to thank Committee of 100 members, Gary Locke, Frank Hu, and Nelson Dong for all of their work on today's event. I want to thank all of our fantastic speakers, Congresswoman Judy Chu, Attorney Ashley Gorski, Andy Kim, Professor Margaret Lewis, Attorney General William Tong, and Congressman Ted Lieu. I want to thank Committee of 100 member Dr. Jeremy Wu for being one of our commentators on the white paper. I want to thank our other white paper commentators, Ashley Gorski and Patrick Toomey of the American Civil Liberty Union, Dr. Randy Katz from UC Berkeley, Carol Lam of the Southern District of California, and Margaret K. Lewis of Seton Hall. All of their expert commentaries are available for download on our website. The recording of this event will be made available approximately 24 hours after the event concludes. I encourage all of you to visit committeeof100.org to download the full white paper, as well as the commentaries, our press release, and open letters from the Committee of 100. Have a great day, and thank you for joining us.